Good afternoon, everyone, and welcome to the fourth in our series of ACC-Baltimore webinars with our premier sponsors. Today, we are very pleased to have with us a panel of attorneys from Miles and Stockbridge and an in-house counsel from the University of Maryland Medical System. This webinar is being recorded. The recording link will be sent out to all ACC-Baltimore members after the program, either later today or tomorrow. We will also be making the slides available separately to our members. If you have a question during the presentation, there is a chat box. Please type your question in the chat box. Both our moderator and I will be looking at it, and if it appears that the question should be asked at that particular point, or if it can wait till the end, we'll make that decision. If we have time, we will open up for questions at the end, and we'll open up all the microphones. So just be aware of that. But if you have a question you want answered, please do type it into the chat box. So obviously, particularly considering Governor Hogan's latest press conference yesterday afternoon with some opening up, but not the removal of the stay-at-home order, but the thought that perhaps in another week, the stay-at-home order may go away. This presentation is incredibly timely. I know all of the nonprofit boards I'm on and all of my friends and businesses are looking at how we are going to operate in the post-COVID environment. So this presentation is extremely timely. I am pleased to introduce Suzanne Decker of Miles and Stockbridge, who will be our moderator. And we have Catherine Widmeyer, who's at the University of Maryland Medical System. We have Stephanie Barron, Kirsten Erickson, and Veronica Jackson, all of Miles and Stockbridge on the panel. And I am going to turn things over to Suzanne, and they are going to be in control of the screen, I hope. Last time I was also in control, which created some flipping back and forth, but I don't think that's going to happen this time. So we are looking forward to a great presentation, ladies. You are unmuted and you should be ready to go.
All right, we're out of the blocks, right? So
Yep.
Good afternoon, and thank you for spending an hour with us today. I was gonna say thank you for spending your lunchtime with us, but I found since COVID, my lunchtime is anywhere between 11 a.m. and 3 p.m., kind of depending when I get up and what my workday rolls out to be. But so whatever period of time this is for you, thank you for joining us. And thanks to Lynn and the Baltimore ACC chapter for partnering with us on this presentation. You've already been introduced to our speakers from Miles and Stockbridge. I'm Suzanne Decker. I'm the co-chair of the Labor and Employment Group. Our speakers, Stephanie, Christy, and Veronica, are partners in the Labor and Employment Group. If you want to find out more about Miles and Stockbridge or our COVID resources or our speakers, please just go to mslaw.com and you can find out more about us. We do have an extra special guest with us here today, and that's Kate Widmeyer. She is the Associate Counsel at the University of Maryland Medical Systems, and she's going to actually bring the practical approach to this, right? The lawyers can sit in our glass towers and give all kinds of advice, but it's you who are out actually dealing with employees on the day-to-day, and you have sometimes a different perspective than we can. So Kate's gonna bring kind of the real world approach to this. And as Lynn said, why are we even interested in this, sort of talking about a return to work? And well, as we all know, things are starting to lift, but many employers already had people coming into workspaces and interacting. And so all of what we're gonna talk to you about today is going to apply in that event as well. But we know that many of you who have had a majority of your workforce working from home haven't had these challenges yet or anticipating them. We do know that Hogan is in the beginning of starting to think about the staged plan, the phases for opening. We're hoping that phase 1 starts soon, but we do know that fishing and golf and camping have already opened as of today. And I suggested to my husband this morning that the best Mother's Day gift possible might be taking our teenage daughters camping and leaving me back behind. Full advantage of of the governor's order this weekend. I had no takers. We're going to talk about today: health screening and privacy issues. When your employees come into work, what are your OSHA obligations? While many manufacturers have always thought about OSHA, white collar environments really haven't. And so that's going to be a change for us. And finally, compensation, leave, and recall issues. And so without further ado, we're going to start with Stephanie.
Great, thanks, Suzanne. I don't know, hopefully you all are having a more balanced lunch than me. My lunch these days is mostly just consists of large quantities of children's snacks. But today I'm going to talk to everyone about health screening and ADA privacy issues. And obviously this is an area that certainly has been impacted by COVID and is much different than the rules that might have applied even just a couple of months ago. So for those of you who have been operational, perhaps you're already involved in screening of your employees before they come to work each day. The rules are really vary. There's no explicit federal guidance on this at this point, and the state law guidance varies significantly. Some have actual requirements, some have recommendations, and some have nothing, no guidance at this point. Maryland in particular, as everyone knows, we're now required to wear masks in public places, but there's no specific guidance at this point around health screening. Perhaps once the stay-at-home order is lifted and more folks are allowed to return to work, there will be additional guidance issued in that regard. But at this point, certainly it's recommended, if not required, that you should be screening employees each day before they come in. And that may include things like taking temperatures, interviewing employees to determine whether they've been exposed or experiencing symptoms or reside with someone who has COVID or has been exposed to COVID. And one important thing to note is that this really applies to everyone who's coming into your workspace, not just your employees. So if you have customers, vendors, other visitors who are entering the workspace, you're going to want to think about how you can screen those folks, especially where you're in an indoor environment, and to start thinking about that and having that in place. Suzanne, can we go to the next slide, please? So of course, this raises a number of concerns and things that you would not have had to think about prior to now. The first and foremost is who's going to be responsible for this screening. Is this something you have the capability to do in-house? Do you want to hire a third-party vendor to handle it? Can your employees do some kind of self-reporting, and will that be sufficient? Again, there's not a lot of guidance at this point, so there are a number of ways that you can handle it. And depending on your workforce, the type of environment that you operate in, whether you have medical personnel or other folks who might be able to handle something like this available, that may determine who's going to be involved in the health screening. But you also have to think about the equipment. If you're going to take temperatures, how are you going to get the thermometers? They're certainly in short supply at this point. And even if you're able to get the supplies, how are you going to handle social distancing? If you have an employee who's responsible for taking everyone's temperature, they're going to have to get within 6 feet of them. And what will that look like, and how will you protect them? We'll talk a little bit later about masks and other PPE. How will you obtain that? All of those are factors that you're going to have to think about. And COVID testing specifically, if you have an employee who's showing symptoms, are you going to, how and when will you determine when the employee needs to be tested? Will there be sufficient tests available? That continues to be an issue, even in Maryland, and even though we've now obtained those 500,000 tests from South Korea, there still remain testing issues and concerns. And of course, who's going to pay for all this is a good question. Generally, if you send an employee for a medical exam, the employer is responsible for paying for that. And that likely will be the case here. But it's not entirely clear at this point. And really, these are all big concerns and big questions that remain unopened or unanswered in a lot of cases. So the good news is there's flexibility because there aren't a lot of regulations. And so you have room to make a plan that will work for you in your work environment. But you also, of course, want to make sure you're doing everything necessary to keep your employees and your customers safe. So of course, a big concern with any kind of health screening, and something we have to keep in mind, is this is confidential medical information. So your employees' temperatures, their symptoms, how they're feeling, etc. All of that is medical information. And again, under normal circumstances, under the Americans with Disabilities Act, you wouldn't necessarily be able to inquire and keep all this information. Because of the COVID pandemic, the EEOC has expanded employers' rights to request and seek this information. But you still have to remember that you have to treat it as confidential medical information. And that again goes to the question of who you're going to have doing this medical screening. You want to have somebody that you trust and is able to understand the importance of keeping it confidential, and won't disclose it to other coworkers, et cetera. Any disclosure is going to have to be on a need to know basis, but there remains a pretty big question about who needs to know, and balancing the question of employee privacy against the need to tell other employees who may have been exposed. And again, the EEOC has recognized that there may be a need to disclose information in this case because of the safety concerns. And so whereas normally we wouldn't share any medical information with coworkers, in this situation, you may be able to share. Of course, you try to do it without identifying the employee. The best course of action would be to tell coworkers, someone who you work with has tested positive, not necessarily, Joe Smith has tested positive. But you do want to balance those interests, and the EEOC has recognized that because of the safety concerns, there is more flexibility in disclosure here.
All right, so make sure.
One more. There we go. Thanks, Suzanne. So again, usually the EEOC limits when you're able to do or conduct medical inquiries and tests to situations where there's a business need to know or a direct threat to the workplace. Essentially, the EEOC has come out here and said, because of the pandemic and the community spread that's out there's almost like an assumed direct threat. And as a result, the health screening is permissible in this pandemic. And again, in some states, it's now required. So you certainly can be taking temperatures and making these inquiries, and you should be sending sick employees home. If you're operating now, and if you're planning to be operational, you should have a well-publicized policy advising your employees, if you are not well, you should stay home. In Maryland, you're required to provide, or if you're 15 or more employees, you're required to provide paid sick leave. We make that available for a reason. Use your paid time off if you're ill. Please do not come into work. You want to publicize that, and that is the expectation, and certainly send folks home if they're not well. Normally, of course, if you have an employee who's out sick for a period of time, you're entitled to, and most do, request a fitness for duty note in order to return to the office. The EEOC says you can continue to do that in this situation with the pandemic, but you should note and expect some need for flexibility, because the ability to obtain that kind of note at this point is challenging. Not many folks can't get into their regular doctor's office, and you may have to provide some flexibility or leeway in that regard. And then finally, and we'll talk a little bit more about this later on in the presentation, but keep in mind that if you have an employee with a disability that is impacted by COVID, you may have to engage in the interactive process, just like you would with any other disability or disabled employee, to determine whether there's a reasonable accommodation you can provide them in the workplace. And there are lots of different things that can look like, from leave to certain specified workplace or otherwise. So we'll talk a little bit more about that in a bit.
Thanks, Stephanie. So now we've got this guidance. We have an idea of what we might want to put in place. Kate, what have you seen in your organization about how to screen employees and think about when they come to work during the day?
Yeah, thanks, Suzanne. So the medical system, like other healthcare facilities in our area, is in a unique position in that we have a lot of brave men and women who come to work every day, and not only come to work, but come to work to provide direct patient care for COVID positive patients. So we have folks entering the workplace, who are caring for these folks. We also, for a later part of the presentation, have a large number of people teleworking, like yours truly. So we've really had experience with both sides of this. issue. With regard to screening, we've done it all. Initially, when the pandemic first, the emergency was first declared, we relied on self-reporting from our employees. And then as things progressed and it became, more serious and we began to understand what was happening, we actually moved to using our time clock. And so if you're a large employer, you might have a time clock that allows you to do attestation at the clock for things like lunch breaks. And so we were able to build screening questions into the clock when you punched in to see whether individuals had flu-like symptoms. And folks were using that. I'll tell you, I pulled the data from our most recent pay period at one of our larger facilities, and 99% of people coming in are reporting no symptoms, which tells me that people are not working sick, which is a great thing. But it is working. So sometimes people are responding yes, and then when that happens, they're sent home before they even start work, and they're directed to employee health for further guidance. More recently, within the last few weeks, we've also started temperature screening. And I think as Steph noted, that can create some challenges with logistics and getting people in and out of the building. And the way that my folks are telling me that's being handled is, making sure that you have enough people to do the temperature checks when people enter the building, making sure you're accounting for distance as people come in. Sometimes at entrances we get bunched up at shift change, but making sure there's enough space, enough people taking temperatures. And also, I think a really great idea that our teams had was we have you can be screened with our thermal scan thermometers, but we also have a BYO thermometer policy, which allows people to take their temperature and not get within 6 feet of folks or be touched by a thermometer that, even though it's got protective casing, has still been used that morning. So that's working very well. That's working out as well.
Did you ever consider allowing the employees to take their temperature at home and simply kind of certify or self-report later?
So we certainly do that. We did that initially, right? Folks were taking their temperature at home. And when people are sent home from work or they are not reporting to work because they're symptomatic, they're self-monitoring their temperature at home to see when they can return. And we're following, the CDC has issued guidelines for return to work for healthcare workers, and we're following those to determine when folks can come back to work, either when they're simply a person under investigation at PUI for COVID, or if they've had a positive test. And I would, the CDC and OSHA have a wealth of information out there about COVID-19, and I highly recommend it to anyone on the call to take a look for guidance on workplace issues.
Do you feel like your employees are pretty honest about their own symptoms?
I think so. I think they have been in this case because of the seriousness of the pandemic. Perhaps, for those of us who practice in labor and employment law and work largely with HR, we see people working sick often because they don't want to trigger a no-fault attendance policy or, burn through their PTO. But I think as employers, we need to be more lenient with those policies now, because it's really important that people not work sick. And for that reason, folks are reporting and being honest about their symptoms.
That's great. All right, so now we turn to, OSHA and Veronica. And this is an area, like I said before, I don't think that white collar environments have really thought about PPE in the way that Kate is. And when Veronica's done with her section, we'll go back to Kate and get a little insight on that.
Thank you, Suzanne. Well, the OSHA requirements for most industries do not have specific guidelines. So unless you're in the example of the healthcare industry or death care, there really isn't specific guidance from OSHA about how to handle occupational safety issues. But generally speaking, there is the general duty clause, which requires employers to furnish each worker and their place of employment and make sure it's free of recognized hazards. And the key word there is recognized hazards. And in the instance here of a pandemic, a COVID-19 exposure does rise to that level. So what I'm going to be talking to you about today is a number of safeguards that OSHA has laid out. And they laid out a very comprehensive guidance which is available on their website. I think our department blog also has an article with a link to it if you're interested. And it goes in great detail. It's very helpful, talking about the different sorts of regulatory requirements, at least guidance for that employers of all types should implement. Now, one of the exceptions to this beyond the general duty clause is in instances of healthcare, nursing, and death care workers. And interestingly, we've seen that unions have been particularly active trying to pressure OSHA to issue additional guidance and specific regulations for groups such as grocery workers and service providers. So many states also have their own safety standards which impose similar obligations. So for example, in Maryland, it's the Maryland Occupational Safety or MOSH. Next slide, please. So under this OSHA guidance, the first thing an employer needs to do, and for most employers, they might have already done this to the extent they're still open and have a physical workspace, is perform a hazard assessment. And the first step of that is to determine what level of risk your employees have when it comes to that recognized hazard here, the COVID-19 exposure. And that might not be the same across the board. So for example, in Kate's instance, the employees that are working directly with COVID-19 patients have a much higher hazard as opposed to, don't you love when you have an incoming call during the webinar? And versus someone who's an office worker might not have that same lower threshold. And based on the amount of risk that individual employee groups have, they want you to implement a basic infection prevention measures. And the most important thing from this OSHA section that I want you to take away is that not all of those workplace controls are created equal. As far as OSHA is concerned, they have a much higher preference for employers to implement engineering and also administrative controls compared to the use of PPE and cleaning supplies. And the reason for that is the engineering controls require less work on the employee side to implement. So engineering controls might be things like the sneeze guards that you see in supermarkets and Costco, or adjusting the HVAC ventilation system to make sure that air is being filtered and circulated up as opposed to around an area where people might be sharing the same contaminated air. And you want to make sure that from the administrative side that you have an infectious disease policy, that you've thought about things like scheduling and training, so that to the extent that there are things that you can do not only in the physical space, but the policies and how your workers operate, that you've made those changes. And then finally, things like PPE, which require have a much higher margin of error because they require the employee to use them. You want to make sure that you have adequate supplies to the extent it's necessary to either provide the PPE or necessary cleaning supplies. And you want to communicate about these flexibilities and have a way to document how you've communicated that to your employees. So that might be a morning huddle meeting, or maybe an actual detailed training. And in those training communication measures, be sure to communicate to your first line supervisors to report back to you if employees have questions, if they find that there's some sort of flaw in the process that might need you to tweak that system. Next slide, please. So the other instance where OSHA will be looking, and this would fall under both mostly administrative control, is social distancing in the workplace. And likely the CDC and other agencies will continue to recommend and even require social distancing in the workplace. And of course, that'll mean the 6 feet apart and not to gather. So that'll mean things like changing outdoor spacing to make sure there's adequate space outside for break areas, rearranging office space. And it's important to keep in mind that that also might include altering work schedules so that not the same amount of employees are in a physical office. Things like cubicles or other open air work environments might need to be modified so that people are not in close proximity to one another. And obviously business travel, currently that's the recommendation that there's no non-essential business travel. Next slide. As for OSHA reporting, there is not an obligation presently to report to OSHA or the state equivalent if there's an instance of COVID-19 among one of your employees. And that's mainly because it is not assumed to be work-related. The exception to that, of course, is if there is a widespread outbreak that it can be pretty clear originated in your work environment. So think of the outbreak in the nursing homes in Northern Maryland or at the meatpacking factories on the Eastern Shore. In those instances, you would need to notify, and even CDC was on site there to address it. But otherwise, there's the assumption that it cannot be tied to a workplace if you have one or two employees coming up positive with COVID-19. Next slide. So Stephanie touched on this earlier, so I don't want to spend a lot of time on it, but on the topic of masks and PPE, now remember this would be on the lower preference side of safeguards that OSHA would want an employer to rely upon to protect against that known hazard of COVID-19 exposure, but still in most instances a likely step because, you know, CDC in most states are now recommending and in some instances requiring that everyone wear a mask or some sort of face covering when they're outside their home. And that will likely continue beyond phase one of, you know, the return to normal plans that our state is rolling out. Employees will likely be required to wear at least some of that at work. So the question will be, how are you going to ensure that that is done in a way that is proper? And that won't be the same for every type of employee. So for example, if you have an employee that is high risk, you have to ensure that you have additional measures, not just giving them an N95 mask. Those require proper training, fitting, and there should be some sort of documentation to confirm that you've done so. Next slide, please. Who's responsible for supplying and paying for the mask? I think in most instances, to the extent of requirement for a workplace, especially when there's higher exposure, you want to assume that you have some sort of obligation to provide those to the extent that you can, especially for higher risk employees. But do-it-yourself options are probably okay, particularly for maybe an office setting. But you just want to make sure that employees are still using them properly and meeting some minimum threshold. You don't want to allow employees to be like the people I've seen in the supermarket with the mask down below their nose or the mouth cut out. Again, that's going to require some sort of auditing and check and a minimum level of training from your supervisors, even in the instance where an employee is using a do-it-yourself option or one that they've brought from home, that it meets some level of standard either from the CDC or the state requirement. And in the instance of an employee refusing to wear it, that would still fall under that same category. Thanks, Suzanne.
Thanks, Veronica. So now we're going to switch back to Kate for a second to find out how this actually all works out. So Kate, when Veronica was talking, she mentioned that some of the reporting issues you see more in a healthcare area or industry than you do in the regular because it may come up more often. Do you foresee any challenges in that area that even non-healthcare employers should be thinking about?
So to me, the challenge for non-healthcare employers will be determining whether exposures occurred in the workplace. And the guidance I've seen, again, from OSHA is helpful for non-healthcare or death industry employees, is that you can assume that it's not a workplace exposure unless you have pretty objective evidence to the contrary. So my advice would really be just to familiarize yourself generally with OSHA's reporting requirements if they in fact apply to your industry. That's the OSHA Form 300. It gets filled out when you have an employee workplace injury or a death. And then make sure that whoever in your organization is responsible for employee health and safety is keeping those logs. And that's because if you do, unfortunately, have to report an injury or a death to OSHA, when MOSH comes in to do the inspection, they're going to want to see those logs. So making sure you're familiar with the reporting requirements, if they apply to you, and that your folks who are responsible understand them will be really important. I'll also just mention, because it's a short turnaround time, that in the unfortunate event that you do have an employee pass away as a result of a workplace exposure to COVID or any other kind of workplace injury, OSHA expects reporting within 8 hours. And so that's a really short turnaround time, and something that is good to keep in mind, to remind your safety folks of that if they're not already aware. I do, if I can, Suzanne, I want to piggyback on something Veronica was saying about communication, because I think it's so important. Communicating to employees about the steps that you are taking to keep their workplace safe, I think, is critical to keeping the trust of our workforce and keeping our operations moving going forward in what's really an unprecedented time. And our experience with this has been with regard to the changing use of PPE in the healthcare industry, right? So everyone has seen the news, there's a shortage of PPE, and that shortage has caused us and the CDC to reevaluate how we use safely and reuse PPE. And that obviously causes understandable concern among the workforce. Just as non-healthcare employers, I think when you have individuals returning to the workplace, they will be concerned as well. And what I think, in my opinion, what our organization has done well is really communicating early and often to staff about these issues and giving them the opportunity, as Veronica mentioned, to ask questions and express concerns, and just making sure they have the information that they need to feel confident in the workplace. I know it's not a legal issue, it's sort of the varsity HR hat that we sometimes wear, but it's really, I think, important moving forward.
No, that's really helpful, because what I think we're seeing a lot of now, even with the employee who just sued Walmart or his family sued Walmart for the death, is wanting to show that we're doing these things correctly in the workplace, whether you're a healthcare provider or a law firm, is that what steps were you taking to keep your employees safe? And that's going to help in an OSHA challenge. It's going to help in a workers' comp challenge. It's going to help in a discrimination claim if they come related to the environment that you had there for your employees. And so all of this, I think, is advice that sort of applies to everyone. And with that, then I guess we jump to Christy, who's going to talk about some of the recall issues.
Okay, but first I'm going to start with the fun topic of compensation, because anybody who's in the labor and employment realm knows that wage and hour lawsuits have been increasing for the past decade, and we don't expect the COVID pandemic to change that. And in fact, we're anticipating more and more suits. So Suzanne, you want to switch the slide? Some questions and things that we think are going to come up that are particular to what we're seeing as a result of the pandemic. So the health screening that Stephanie talked about. Do you have to pay your hourly employees for time spent in health screening every day? The legal answer is maybe, or it depends. I suppose that's the lawyer answer we all get. I'd say the legal test on this is vague. And I will tell you, there is not a single ounce of guidance as to whether temperature screens are compensable or not. So my advice is pay them, because it will be much cheaper in the long run to pay each of your employees for 10 or 15 minutes a day while they wait to get screened than it will be to establish whether they need to be paid in a wage and hour class action lawsuit. So that is a practical piece of advice more than a legal piece of advice. But I think the answer to that is do it for employee morale and do it in the interest of just being conservative and trying not to get yourself sued. Can I reduce pay? Yes, you can. Unless you have an employee with a contract that would prohibit it, for all at-will employees, you can reduce their pay. It's easy for hourly employees. All you do, you need to give notice in many states. In Maryland, it's 1 pay period. In some other places, it may be a different amount of time, and sometimes there may be a requirement that it be in writing. So check the state law where your employee is before you do that. But generally, there will not be a prohibition against reducing an employee's pay. It gets a little more complicated for salaried employees if the reason you want to reduce their pay is because they're doing less work, you're furloughing them, they're working a schedule where maybe they're working 3 days a week or 4 days a week instead of 5 days a week. Because in order to be exempt under the overtime tests, they need to get the same salary regardless of the number of hours that they work. There's a recognition that due to economic circumstances, you can reduce the pay of an exempt employee, but just be careful that it doesn't, that you're not explicitly tying it to a reduction of hours, and be very careful about how often you do it, because the more you do it, the more it looks like you're trying to make an end run around the requirements that you pay someone regardless of the hours that they're worked. So my advice is if you want to bring them down once, that's great. Every time you do it beyond once, I think increases your level of risk in that area. And again, there's no bright line on that. That's just a practical piece of advice for me.
So Christy,
Yeah.
can I ask you a question? Because I just want to clarify. I think you could reduce an employee's FTE, right? So I work, 40 hours a week. I'm a 1.0 FTE, and I'm now only going to be required to work 36 hours a week. So I'm a 0.9. I would think the LSA would let you reduce in that circumstance, as long as you said, you're not bumping it around to make it look more like they are hourly than they are.
Right. And then I think in that case, you are essentially changing their job requirements. And so it would be tied to the job requirements. But most people aren't doing that. And again, I think if you move it down and then move it back up, it's the same risk. But if you're changing their FTE and what used to be a 40-hour-a-week job is now a 30-hour-a-week job, and that's the expectation, then a reduced salary that goes along with that may make more sense. But most people aren't, I think, being that sort of deliberate about it. They're just saying, we have less work, we need to cut pay. So it's really about creating a proper record and proper documentation so that if there's a challenge later, you're in a better position to defend. So can I pay more, hazard pay, or bring people's pay back up if I had to cut them? Sure, no one ever complains about that. But again, the FLSA can throw some wrinkles into that, because if you have hourly employees who have been working overtime, there are certain bonuses or additional payments that need to be included in the regular rate of pay and could impact overtime, even past amounts overtime that have been earned if the bonus relates to that past period of pay. So those rules are very arcane and won't bore any of you or spend the time on it now, but if you're thinking about doing something like that, make sure to check the wage and hour rules, check with your legal counsel to make sure you're doing that in a way that isn't going to create an unintended liability. The other thing that we're seeing is that a lot of people suddenly had to shut down and move their operations online. And that included not just salaried workers, but hourly workers. And telecommuting for hourly workers is fraught with danger because of the requirement to track the hours that are worked, because of requirements for breaks in some areas of time to make sure that you have proper timekeeping, for paying people for working maybe outside of regular work hours, all of which are a lot harder to manage and keep track of in a remote work environment. So you really need to make sure, if you ran off and went remote without thinking about a lot of those things or putting policies and protections into place, that you go back and do that and try to make sure that you're fixing any problems that you're seeing to try to avoid issues going forward, because this is going to go on. This isn't, oh, we're just going to telecommute for 2 weeks. This is now going to be happening for some period of time. So just, again, there's lots of rules about it. It's one that you should do with, legal advice and counsel for sure. All right, next slide. So, and what about leave, sick and vacation leave? In many workplaces, even those where people weren't furloughed, because of reductions in work hours, people have been using their PTO in order to get paid full amounts, and they may have exhausted all of their leave. So how are you going to handle in the next 6 to 7 months of the year people who have vacations or illness and holiday times and things like that? For the most part, that will be a business issue, not a legal issue that you'll have to make decisions on based upon operational requirements, employee morale, and things like that. You'll have choices available to you. The one place where you may have a legal issue is if you're in an area where there's a mandatory state or local law providing for paid sick and safe leave. So if employees exhausted PTO, especially if you made them take their PTO for a week or two of administrative leave or furlough time, they may not technically have had the opportunity to use that time for sick leave. And so I think there is some risk of claims if people then come back in September and get the flu and need time off. I think you want to be, again, as Kate said, sort of flexibility is the key here. You know, think about, is there a potential for a claim there? Is it better to provide 2 extra days of sick leave to people to avoid that issue? Especially because that's going to tie into sort of the policies about returning to work and keeping a safe workplace. So it may not be the place that you want to kind of nickel and dime people. Think about if you laid people off or furloughed people, the fact that you bring them back, you may need to reinstate their paid sick leave balances. Most paid sick and safe leave statutes have a reinstatement requirement, depending on how long the employee was out of work for you. And then keep an eye out for new laws. We're seeing in some states COVID-19 mandatory sick leave requirements and things like that. I expect we'll continue to see that in some localities. So be on the watch and be aware that that may be coming and be prepared to react in the moment like we always do. All right, next slide. More leave. For those of you who are subject to the FFCRA, who are under 500 employees, remember that that's not just during this brief period of sort of pandemic emergency. Those requirements remain in effect through the end of the year. For those of you who may be on the bubble, understand when the 500 threshold kicks in. It is a determination that is made at the time the employee asks for leave. So if you are laying people off and you were over 500 and now you're under 500, you may find yourselves in coverage, or you may be bringing people back and find yourself out of coverage. So while it is odd to think that it could vary week by week or month by month, that is the measuring stick. And so you need to be, you know, paying close attention to your headcount if you're somewhere kind of on that bubble. You may, for those of you who had employees that have been laid off or furloughed, you didn't have to worry about providing leave because the reason employees couldn't work was because you had no work for them. You may find yourself now in the strange circumstance where you ask someone, like, ready to come back to work, see you on Monday, and they say, I can't, my kid's off of school and I need time off because I can't work, because I have to care for my child. So once you have work available and have made that available to somebody, they now are in the situation where they may be entitled to that leave, and you have to go through the process of evaluating that request and giving them paid leave, even if they frankly never report back for a day of work. A small piece on the emergency FMLA, remember there's sort of a 30-day qualification period that could have been satisfied pre-furlough, so someone doesn't have to be back on the books for 30 days. It's just they had been employed for 30 days. Question I'm getting a fair amount now is that if summer camps aren't in session, is lack of summer camp going to qualify for lack of childcare for my kids once school is out? Here's one area where the Department of Labor actually thought ahead, and the answer to that is yes. A summer camp qualifies as a place of care. So if you normally send your kid to the YMCA camp for a week and the YMCA camp is closed, that you will have a lack of childcare that would qualify for leave under those circumstances. Next slide. All right, so we've already heard some about ADA and FMLA. I really expect claims are going to increase, and we're going to see particular increases, not just from individuals with underlying health conditions, as sort of Stephanie mentioned, but claims for people who particularly may have mental health conditions, such as anxiety and depression, that are already exacerbated by the level of anxiety generally in the world, but will likely be exacerbated by the idea of coming back to work under current conditions. And you know, we're going to have to be ready to be prepared for that. With the FMLA, a couple specific points to keep in mind. One, remember that emergency FMLA under the FFCRA counts those, if an employee takes 12 weeks, that counts as their 12 weeks of FMLA. It's not a new measuring period. With respect to doctor's notes, Stephanie mentioned this again, but be prepared that if you want a health certification to justify FMLA leave, it will be hard for employees to get that within the 15 days that the FMLA requires. Right now, I don't see any indication that you can't hold tight to that and not, hold people out or deny them leave if they don't get you the certification back in time. But again, thinking about bigger picture, you may want to be a little bit more loose about the timeframes that you give people or what you will accept from them in terms of a health certification in order to do your FMLA administration a little bit more smoothly. That's perfectly acceptable, but just be careful that if you are going to do that, that you are making global policy decisions and not case-by-case decisions depending on who it is that's asking for the leave. Another interesting wrinkle, and maybe only for the legal wonks, is that the actual definition of someone having a serious health condition under the FMLA definition requires them to go to a doctor, and it requires an in-person visit to a doctor, which, as we all know, isn't happening much these days, although that may start to change. And so again, you may want to loosen up a requirement, the telemedicine or some other type of appointment with a healthcare professional that doesn't count as an in-person doctor visit. You may want to loosen up what you're requiring in order to be a little bit more, let people take leave a little bit more easily. We're also expecting to see increased requests for remote work. And while there was a lot of pushback pre-COVID-19 about employees teleworking and that either could be an undue hardship or that a job could not be performed remotely, that's gonna be under challenge now because many jobs have been performed remotely for the last 8 weeks. Question how well in some circumstances, but your employees probably think they've done a really good job. So we're gonna expect to see the undue hardship of that get tested as we go forward. And certainly with employees who are concerned about the workplace itself. So if I have an underlying health condition and I am at an increased risk, I may ask to telework so I don't have to come into the workplace. Will additional PPE or additional protections or modifications to the work environment sufficiently protect that person? We'll have to see, but remember that if they do, if there is more than one accommodation that might be effective for that employee, the employer still does get to choose. So you may be in the position of having to make decisions about allowing or not allowing telework. I will also say, again, with respect to teleworking policies, if you're going to have more employees working from home because of ADA accommodations or things like that, it's really important to have policies in place that talk about responsiveness, communication, privacy, safety, all of those things that, again, many employers who didn't routinely allow telecommunication or didn't have a lot of it didn't have in place. But the more people that you're going to have working remotely, the more those policies are important, especially if you're concerned about people's ability to maintain their level of job performance. You may let them go out as an ADA accommodation, but then you need something to have to do performance management and something to measure against. And that's where a telecommuting policy can be really important and really effective. All right. We expect to see more discrimination claims. Some may be on national origin. I'm sort of hoping that we've moved beyond blaming the Chinese for this virus, but you never know. But I think really what we're going to see is we're going to see disability claims and we're going to see age claims. And the reason we're going to see them is that those are the two populations that are the most vulnerable to the virus. And so, is COVID-19 itself a disability? Probably not. Maybe if there are severe complications to it, but it's really going to depend on the facts and circumstances and how sick somebody gets from it. What we are, and then medical inquiries, which Stephanie talked about, again, the privacy concerns and what you can ask and what you can't ask are all governed by the ADA. The dreaded regarded as disabled claim, I think is what I worry about. The I'm trying to protect my employees, so I'm telling people over the age of 60 or who have underlying health conditions that they can't come back to the office even if they want to. I think that is dangerous, even if it's for the right motives and hopefully in the employee's best interest. I think if you think back to pregnancy discrimination claims, those types of, I was trying to protect my pregnant employee type of facts led to claims. And I think we may see that again with respect to disability and age. So I would say, you know, again, sort of following up on Kate's communication and being flexible and considering requests that people not come in. I think that is the way to go rather than drawing a bright line in the sand and telling people that they categorically cannot come in unless you have cover of a state law or something that says you are required to exclude those people from the workplace. But even the EEOC earlier this week came out with some guidance saying that you could only exclude someone if you could show that there was a direct threat to that person by coming into the workplace. But that's an individualized assessment. It can't be alleviated through some other type of accommodation like PPP. And I think it's just going to be, dangerous. So I think you got to be really careful about trying to navigate and walk that line. All right, next slide. So recalling people, lots of questions that we're getting right now. What if I offer someone the ability to come back to work and they turn me down because they're making more money on unemployment? So if you offer someone the ability to come back to work, then unless they decline that for good reason, they will no longer be eligible for unemployment. And good reason may be I have an underlying health condition and my doctors told me not to come back to work. Not a good reason is I'm making more money on unemployment than I was before. So if an employee refuses recall, the states are all realizing this is an issue. Maryland has a form online that you can fill out that just says, I put you on notice that this person refused recall. And then they will do a determination as to whether the person had a good cause to decline the work or not, and whether that will disqualify them for benefits or not. If you had terminated an employee and you bring them back, if it was less than 60 days, you need to do, or more than 60 days, you need to do the new hire paperwork. So that will get reported to unemployment and will, stop benefits if the person didn't report or there was a delay in reporting. What's the process you should follow when you are bringing somebody back? So check your handbook. If you are in a unionized environment, check the collective bargaining agreement. See if you may have made any commitments or contractual promises about how you will bring people back and what that will look like and what you do for them. If you don't have any restriction and you're able to bring them back kind of however you see fit, if you're not bringing everybody back, you certainly can select the appropriate people to be back, but make sure that you are basing those decisions on objective business-related criteria. So just like you would do in a layoff where you look at your employee population and you see who's coming back and who's not, making sure that you don't have adverse impact based on gender or age or race or retaliation. So make sure that the only people that you're not bringing back didn't request sick leave or an accommodation under the ADA, because you'll be setting yourself up for a discrimination or retaliation claim. So set out your criteria for who you're going to bring back, apply that to your population, and document what the selections were made and why. All right, next slide. And then, sort of as Kate said, I think the idea about employees being just generally afraid to come back and making sure that you are thinking about why they're afraid, what are your legal rights and obligations with respect to the various reasons that they're expressing, and then generally as a HR issue, how are you going to address the practical ones that may not be legal ones? So why are they concerned? Again, if it's an underlying medical condition, you may have an ADA issue and there's going to be legal requirements around that. A lot of people are afraid about coming back because they have a family member at home that has an underlying health condition and they don't want to get sick and bring COVID-19 back home. So that's not an ADA issue because the employee, him or herself, is not disabled and there's no sort of associational disability accommodation. So it's not an ADA issue. If they're not needed to care for the family member, it's not even going to be an FMLA issue. It might be an emergency paid sick leave issue if the family member's doctor has told, the spouse, don't go into work because you don't want to bring germs home to your wife. So you may be able to get paid sick leave there, but that's likely not going to be legally protected, but it's going to be a significant practical issue you're going to need to be ready to address. And then again, the generalized fear of getting sick, not legally protected, but a big HR issue that you're going to need to be ready to address for sure.
Yeah, Christy, I would just add, and I'm sure many people on this call have had the experience of people who are concerned about their family members, right? Because they don't want to be exposed and maybe even be asymptomatic and bring it home to people that are at risk. And there is no good answer, I think, for that predicament other than to say, to exercise accommodation when you can. Right? I mean, we all have operational concerns. The businesses have to run, the hospitals have to run. But, when you can accommodate in a fair, an equal way, I would recommend doing it. Again, because it's such an unprecedented time for people and we need to understand that many of these concerns we share ourselves. So.
We did have a question that came in, and I think it would be great to hear from one of our practitioners and also from Kate on this, which is really more of the practical. You've got an employee there's someone in their home who has COVID-19. What is the advice you're giving generally about how long to keep that employee out of work or at all? I know that the CDC has put out guidance that sort of indicates there are ways to permit someone who's been exposed to come back to the workplace immediately, but would love to hear, maybe Stephanie, I see you're unmuted. What are you advising clients on that? And then we'll go to Kate, because I'd love to hear what she's thinking in terms of the healthcare worker perspective.
It's definitely a tough call, because like so many other questions that we're dealing with, there aren't a lot of clear answers as to whether or not how long they have to stay out. But I think generally following the CDC guidance is probably the safest, which is the 14 days. So for the most part, it's obviously easier if the person can work from home during that time period. But if they can't, I think that's certainly the safest. Kate, I don't know if you disagree.
Yeah, I'd love to hear sort of your thoughts on that, where the person may have been exposed. We don't have any idea whether they're going to be positive or negative.
Yeah, so I wish I could tell you that we had come up with a solution to this, because I will tell you that the health and safety of our employees within UMMS and their families is really our highest priority. But I did see this question in the queue, and so I phoned in a friend in HR while the presentation was going on. And I think the advice would be to self-quarantine as best as you can in your home, using the infection prevention measures that the CDC has recommended. And we have provided employees with lots of resources about what those are, right? So we have like a COVID-19 we have webinars frequently with our leaders and others, educating folks on the best way to prevent transmission. And I do wish, it's a concern, and I think we're always welcome to suggestions, but I don't think we've eliminated the risk, except to say, follow CDC guidance and attempt, self-isolation the best that you can.
All right, then I'm going to turn it to Stephanie to sort of give us our practical takeaways. And if others have questions as we kind of wrap up here, please put them in the chat area and we'll try to get to those. Stephanie?
Thanks, Suzanne. I know we're just about out of time, so I'll go over these quickly. But I think the key takeaway, especially for those of you who aren't yet operating in person, and even for those who are but maybe aren't totally ramped up, you're going to want to start planning now if you haven't already, because as you can tell from all the things we've talked about today, a lot of this is going to require advanced planning and thinking about, and perhaps even getting certain equipment or other furniture and things like that. So because you have to think about what your workplace is going to look like. It may be different than what it was, especially if you have folks working in cubes or other close areas, and you may have to purchase different furniture or different equipment to help separate them and enforce the social distancing that likely is going to be required, at least in the short term, and probably even for the longer near-term future. So you want to think about what kind of PPE you will need to supply your employees, whether it's masks or any other kind of equipment, and see about trying to obtain it. Again, as we've heard on the news, it's not that easy and can take a long time. I read something this morning that Clorox doesn't expect to have sufficient wipes to be able to restock stores at this point until perhaps the middle of the summer. So it continues to be really hard to get certain cleaning supplies and equipment. And so the sooner you start thinking about that and trying to work on it, the better. Another thing, we've talked about a lot of new ways that employees are going to have to be operating, whether it's in a different workspace with PPE, what social distancing requirements are going to be required, some of the discrimination things we want to remind people of. Now is a time to consider doing training on all those new changes. And a lot of that can be done remotely while your employees are still home, but you're going to want to provide them with a good bit of information and to be able to show you gave them the training on how to use the PPE and explained what the social distancing requirements were going to be. All of that is going to be part of the return to work process. And so thinking about what kind of training you'll provide and how you'll give that, and perhaps even undertaking it now remotely while folks are still home. And then of course, all of this is ever changing. The guidance is coming out on sometimes what feels like an hourly basis. So try to stay alert of both the federal requirements, any state requirements, and if you, to the extent you have employees in more than one place, you're going to need to follow and comply with the laws of the states, and in a lot of cases, even the localities of where those employees are located. So stay on top of all that. And when in doubt, reach out to your counsel. This is all very complicated and ever changing. We're all certainly happy to answer any questions you have, but don't go at it alone. For some of these topics, they're so confusing that even those of us dealing with it on a day-to-day basis are calling each other to talk through. It's very complicated. So don't be afraid to reach out. So with that, I think that brings us to the end of the presentation. We're certainly all happy to take any other questions that you have. And really thank you for your time today and for participating with us, and hope that you found it helpful.
So this is Lynn Durbin back on, and I would just like to say thank you very much, ladies. I think it was extremely helpful, and the questions are really hard ones, and the specifics will really make a difference, and calling your counsel is an excellent idea. We are at 1:33, so I'm going to briefly unmute everyone. If there is anyone with a burning question that they would like to ask, please ask it now. Okay, not hearing any. We're going to wrap this up, and the video will be available on the website and via a video link in the next few days. So thank you very much, ladies, and everyone. Please stay safe, and good luck as we navigate these changes. Take care.
Thank you.
Thank you.
Thank you.